Well, welcome to Friday. We made it, and still waiting on any kind of resolution out of the Seventh Circuit Court of Appeals challenging Illinois' gun and magazine ban, while the registry set to open in less than a month with the deadline of January 1st in order to file an affidavit with state police or face criminal penalties. We're still waiting on that. But in the Fifth Circuit, you've got the case that the Firearms Policy Coalition has brought against the ATF on the issue of a rule concerning frames and receivers. And yesterday in federal court, you had a three-judge panel hear arguments on both sides of this issue. Welcome back. It is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk, and you can always find me anywhere. Just search out Bishop On Air on X, formerly known as Twitter, Facebook, YouTube, where you can watch live on WMAY's Facebook and Bishop On Air Facebook and elsewhere. So here we are. We've got some of the arguments, and if you can see these yourselves and actually listen to them, simply by going to the Fifth Circuit Court of Appeals YouTube channel and listen to yesterday's arguments, about 30 minutes worth. But interesting to hear some of the back and forth, especially when it comes to the questions that the judges ask. So some background on this particular case out of the Fifth Circuit. You had FPC, the Firearms Policy Coalition, file a lawsuit on behalf of the VanDerStok plaintiff against Merrick Garland and the ATF, and it challenged the frame or receiver rule that the ATF has, essentially saying that a block of metal can be turned into a frame or receiver, therefore that block of metal is to be regulated like a firearm. And these are blocks of metal that aren't finished. They're like lower receivers in the shape of one, but it's not fully bored out to allow for the parts to go in and the pins and the barrel area. So, and even the area where a round can go through and pass through. So it's not a finished part of a firearm, but the ATF says since it's, quote, readily convertible, it is part of a firearm and needs to be regulated. So that's really the crux of the issue here, and FPC suing, saying that the ATF can't just make law by crafting rules. So that's the crux of this, right? That they claim the ATF is trying to make law through administrative rule. So yesterday in the Fifth Circuit Court of Appeals, you had questions posed to the defendants, the Department of Justice, and also the plaintiffs, laying out some of what the remedies are here. But more background on this, you had a district-level judge essentially rule that the frames or receivers rule from the ATF was unlawful, and that was back in late June when the lower court made that determination. But then just a handful of weeks later in July, the U.S. Supreme Court, on request from the defendants, the Department of Justice, they issued an order saying that ultimately they're staying this disposition of the case and pending what happens in the Fifth Circuit and disposition of a petition of a writ of certs for the Supreme Court to take it up. So ultimately they stayed the decision from the lower courts while the issue continues to play out. So at one point, the ATF's rule was vacated, and then it was stayed. That decision was stayed. So the rule is in place now, pending whatever the outcome is of the case ultimately. But let's hear some of the questions that were posed to the defendants in this case. You had the judges asking pretty pointedly about the definition of readily convertible, talking about how one case decades ago, some guy had a Tommy gun and he had poured metal down the barrel and it was inoperable, but the ATF said, well, you could have a metal expert go in and bore it out in 8 hours of work and get this thing to be readily available to be a firearm. So that was seen to be a little bit far of a stretch in a case decades ago. So that issue came back up here, but there was also conversation about, well, is an AR-15 readily convertible to a fully automatic? So here's the judge, one of the three panel, and the attorney representing the Department of Justice, going back and forth on this question of readily convertible.
there's a lot of challenges in this case as to what the word readily means. And ATF has tried to put everybody on notice. As you pointed out, the whole purpose of this rule is to tell the world what readily means. And so you've given us both an 8-factor balancing test and some cases. And the thing, to put a fine point on this, here's what I don't understand. If 8 hours of sophisticated understanding of metallurgy, a well-equipped shop, and ability to saw off a barrel, retap a new barrel nut, put in a new barrel, fix the welds, and turn that into a machine gun, if that is readily, which is what ATF says in the rule, why is it that every American in the United States who has an AR-15 doesn't have a readily converted machine gun? Because as I'm sure you know, and as I'm sure ATF knows, there are articles all over the internet. For pennies, and for minutes, people can turn AR-15s into machine guns by simply changing the sear. You can use parts that you can buy readily available on the internet. You can use coat hangers. This is all over the internet. It's very easy to do. So is an AR-15, in your view, readily, and when I say that, I mean just a semi-automatic AR-15, is it readily converted to a machine gun, yes or no?
So I can't answer that question, Your Honor.
It takes seconds. It takes minutes.
Does not answer that question.
So you can't tell me if something that takes minutes.
In the NFA.
Counsel, you can't tell me if something that takes minutes and pennies to convert is readily converted?
So the NFA, my memory is, Your Honor, which again is not directly issued in this case, includes slightly different language with respect to...
Hold on. You just told me at the outset of this argument that they're the same. There's no difference. Your words, not mine.
No, Your Honor. The word readily appears in both statutes. ATF draws on the bodies of case law under both statutes to define that particular word. That being said, my memory, again, the NFA is not an issue in this case. Plaintiffs haven't raised any of these sorts of arguments.
They absolutely do. They say we don't know what readily means. They say it's void for vagueness, it's arbitrary and capricious, it violates the due process clause. They rate page after page after page. We don't know what readily means. And you can't tell me what readily means. You won't tell me that it means 8 hours of sophisticated understanding of metallurgy in a well-equipped shop, and you won't tell me if it takes minutes and pennies. So what is it?
Look, Your Honor, again, I cannot tell you because I don't know how ATF will look at AR-15s. They're not issue in this case. That being said...
The case is over in this case, the judge says. So obviously you can hear the direction that some of these judges are going in the Fifth Circuit when it comes to the ATF's rule about what is, quote, readily convertible. And the supposition here is that they're just making this up on administrative rule and not going through Congress. So what are the remedies here? The plaintiffs with VanDerStok, they got up and talked about, well, you could either give an injunction or you could vacate the rule. So we'll see what some of the argument is there. Coming up next from the Fifth Circuit Court of Appeals, where we're still waiting on the Seventh Circuit Court of Appeals dealing with the state's gun and magazine ban here in Illinois. The other courts across the country continue to debate what's going on with firearm regulation. So stay tuned. We'll get to more here on WMAY with Bishop on Air and Springfield's Morning News. But we got to take a break, so stay tuned. More up here in just a moment.
That being said, my memory, again, the NFA is not an issue in this case. Plaintiffs haven't raised any of these sorts of arguments.
They absolutely do. They say we don't know what readily means. They say it's void for vagueness, it's arbitrary and capricious, it violates the due process clause. They rate page after page after page. We don't know what readily means. And you can't tell me what readily means. You won't tell me that it means 8 hours of sophisticated understanding of metallurgy in a well-equipped shop, and you won't tell me if it takes minutes and pennies. So what is it?
Look, Your Honor, again, I cannot tell you because I don't know how ATF will look at AR-15s. They're not issue in this case. That being said,
the case is over, says a judge in the Fifth Circuit Court of Appeals yesterday in the challenge VanDerStok v. Garland. And that's the frames and receivers rule from the ATF being challenged. A lower court essentially ruled against the ATF, but the Supreme Court stayed that ruling while a case continues to play out. So the frames and receiver rule is still very much in play right now, but it's in the courts as well. We heard, of course, last segment about the definition of readily convertible, and the ATF defense didn't really have much of an answer to the judge who was providing different questions, poking holes in some of the arguments there. So now let's hear from what the plaintiffs had to say is some of the remedy in these cases. And, you got an idea of a rule. Should it be vacated or should there just be an injunction against the government from enforcing the rule, which keeps the rule in place? It just simply says that the federal government can't enforce it, where conversely, vacating the rule would just set it aside and the rule is done away with. So let's hear a little bit of those arguments from the plaintiffs, VanDerStok, in front of the Fifth Circuit Court of Appeals yesterday on this case.
You don't know what readily means. That's what I heard you say a minute ago.
Here is the plaintiffs describing the different types of remedy that there is.
And that vacatur was the proper remedy. Under Section 706 of the APA, courts are directed. Congress told them you shall set aside agency action that exceeds authority or is otherwise unlawful. And at the time the APA was enacted, Black's Law Dictionary defined vacate. One of the definitions of vacate was to set aside. And the definitions of set aside included annul and revoke, similar terms. Very shortly thereafter, the federal courts understood this language to mean vacate. And similarly, this court's precedent establishes that the language means to vacate. And so I don't think there's any question under this court's precedent and even under the proper interpretation of the APA that vacatur is a proper remedy. The other side raises some arguments how, well, even if vacatur is a proper remedy, it shouldn't be entered in this case. But those two lack merit. First, they say you should have considered an injunction before vacating the rule. But that gets things backwards, because an injunction is only to be entered when there's no alternative remedy that would be remedy the plaintiff's harm. And here there is a statutory directive to courts that you shall set aside unlawful agency action. That's what the Supreme Court said in Monsanto. Before entering an injunction, courts must consider whether a less drastic remedy, such as vacatur, would remedy the plaintiff's harm. So they get things backwards by saying consider an injunction first and then vacatur. The statute and equitable standards say that you do it in the opposite direction.
Assuming vacatur is the proper relief to be granted, is it possible under the facts and circumstances here to limit that to only the named plaintiffs?
No, there's no, I don't know that it's possible in any circumstance to have an as-applied vacatur. Vacatur, as this court said in Data Marketing Partnership, is to formally nullify and revoke a rule. And it doesn't make sense to say a rule is formally nullified and revoked with respect to one party, but it's not formally nullified and revoked with respect to another party. So I think the mistake here is mixing concepts relating to injunctions with concepts relating to vacatur.
So again, some of the arguments that the plaintiffs are laying out is, hey, we need this vacated. Injunction keeps the rule in place. It's a temporary thing. So what's going to happen here? Not sure. We'll obviously update you. But if you want to go listen to that case, it's only a 30-minute worth of actual arguments in the Fifth Circuit yesterday, and you can put it on double speed like I did this morning on my way to work listening to it. So, it's interesting to hear some of these arguments back and forth, but that's in the Fifth Circuit. We're still waiting on whatever happens with the Seventh Circuit Court of Appeals in the challenge of Illinois' gun and magazine ban, but we just listened to some of the arguments back and forth about the challenge to the ATF's frames and receivers rule when it comes to what some call ghost guns, but others would say they're just merely homemade firearms, which you have the right to do. Anyways, interesting to hear those things. Obviously, we tend to start our program each and every morning looking at the various ins and outs of firearms regulations and the litigation against it. So if you need more, you can always follow me, Bishop on Air, at gmail.com, on Twitter, Facebook, YouTube. Just search Bishop on Air.